Hi, Alex Fong here. If you're an independent contractor or a company looking to hire one, you may have ran across or used a services agreement. These agreements will typically contain a work made for hire provision. The purpose of this video is to discuss the problems associated with a typical work made for hire provision under California law. To better illustrate the problem and how to draft around it, I have here a sample independent contractors agreement. As you can see, this one is called a Master Services Agreement, or MSA for short. The name of the agreement itself is not important. As you can tell, this particular one is from Riverbed Technologies. I'm using their MSA as a teaching tool because they are a well-known technology company here in the Silicon Valley, and this is actually one of the better drafted services agreements I've read. It is also a good representative of most services agreements. Recall that there are two basic types of work made for hire. There is work made for hire produced by an employee, and work made for hire that is specially ordered or commissioned. The situation we are concerned with here is the latter case, a work that's specially ordered or commissioned. This means the author is an independent contractor. The independent contractor in our situation is also a natural person and not a corporation or other sorts of legal entities. If we scroll down to section 4.4 of the MSA, we see the work made for hire provision. This work made for hire provision is fairly typical. It basically does three things. First, it declares that any result of the contractor's work to be work made for hire, and that's for this first part here. Second, if for whatever reason the work is judged not to be work made for hire, this provision assigns the work to Riverbed, and that's this part here. Third, if the assignment fails, then an exclusive license without reserve is provided to Riverbed, and that's this part here. So this provision has a lot of belts and suspenders. You might notice that this clause does not specify what sort of work made for hire is being made. But if we look further down in this agreement in section 8.1, it makes it clear that the contractor is not an employee, but an independent contractor. And if the contractor is found to be an employee in any way that might subject Riverbed to any liabilities, the contractor is required to defend and indemnify Riverbed. The implication of this section 8.1 is that we are definitely talking about work made for hire that's specially ordered or commissioned. It all looks seemingly airtight, so what's wrong with it? Well, there are two problems. When this MSA is used to contract with a natural person in California, California Civil Code sections 3351.5C and California Unemployment Insurance Code section 686 become applicable. This is the relevant wording of section 3351.5C of the Labor Code. It defines who is an employee for the purposes of Division 4 and 5 of the Labor Code. These two divisions of the Labor Code govern workers' compensation. As you can see, this clause defines an employee in reference to the work made for hire portion of the Copyright Act. Likewise, this is the relevant wording of section 686 of the California Unemployment Insurance Code. As you can see, it defines the word employer in direct reference to the work made for hire section of the Copyright Act. The effect of these two provisions is that any independent contractor's agreement that contains a work made for hire provision, like the one in this Riverbed MSA, will cause the independent contractor to be reclassified as an employee for the purposes of the workers' compensation and unemployment insurance purposes. Now, you might recall that in section 8.1 of the MSA, the contractor has agreed that his relationship with Riverbed will be that of an independent contractor, and he has waived any right to receive any of the benefits that Riverbed makes available to its employees. That includes unemployment insurance and workers' compensation insurance here. Further, contractor agrees to indemnify and defend Riverbed against any and all such taxes or contributions, including penalties and interests. The problem with Section 8.1 is that the waiver in indemnity and allocations of responsibility may be invalid. Under the Unemployment Insurance Code, any waiver by a person entitled to any of its benefits is invalid, and any agreement that requires any employee to pay his own contributions that should be paid by his employer is void. Likewise, the Labor Code has broad prohibitions against contracts that exempt the employer from liability. Further, no release of liability is valid unless it's approved by the appeals board or a referee. So let's see how we can modify Section 4.4 of the MSA to avoid these problems. First, notice that I have track changes turned on, and you'll be able to see all the markups. Now, of course, we need to delete any references to work made for hire, and that's this first part here, and that's easy. Next, we need to work on the second part. It's no longer conditional because the first sentence is no longer there. So we need to take this part out, and we will obligate the contractor. It reads now, contractor shall and hereby does irrevocably and unconditionally assigns to Riverbed all of contractor's right, title, and interest worldwide and into such deliverables, effective as of the date the applicable deliverable is created. Now, notice that I didn't do anything with the moral rights here, because here, the part I deleted purports to assign the moral rights to Riverbed. Now, under VARA, which is the Visual Arts Rights Act, which is part of the Copyright Act, such moral rights are not assignable. However, they are waivable. So what we should do here is this. Contractor hereby waives any moral rights to such deliverables for any and all uses of such deliverables. Okay. Now, I would like to point out something with respect to the moral rights language I just drafted. Under VARA, a proper waiver must specifically identify the work and the uses of that work to which the waiver applies. If we go back to Section 4.4, you can see that deliverables is not a defined term. And in fact, it's not specifically identified anywhere in this agreement because it's just a template. Now, if we go back up to 2.1, however, we can see that a statement of works is in fact contemplated and would be attached to this agreement as an Exhibit A. And generally, these statement of works will describe the services in the final deliverable. And that should be sufficient for the purposes of VARA. Now, if you don't have a statement of work in the particular document that you're working with, I suggest you create one, or if that's not convenient, describe the deliverables or the work that is being produced, somewhere in the terms and conditions, and that would make the waiver of the moral rights much stronger. It's important to remember that once the work made for hire provision has been deleted from the agreement, what you're left with is either the assignment or the license. These sorts of grants may be terminated by the author after approximately 35 years under the Copyright Act. Now, if the author is no longer alive, that right can be transferred to his children, his grandchildren, his surviving spouse, his trustee, his executor or administrator, whatever the case may be. That's it for this video. I hope you enjoyed it and it will be useful to you. Thank you very much. Bye.